people, good morning. So this is the marathon for your labor laws. So SBIL 40 marks. 40 marks portion is something which we are going to do now. So to start with the labor laws, you should know why such labor laws. Why the concept of labor laws. So I'll be happy if you can close your eyes and think about the scenario. Close your eyes. Think it's like 7 a.m. a cloudy morning, and you see people of different ages. It can be some less than 15, more than 70, 23, pregnant women. What kind of people you can think of? Those people moving towards a particular one iron gate that resembles to be something of a old factory. These people are stepping inside, and now the camera is focusing on the premises, the inside of the premises, where you see a person working. So he is working without helmets and all. Suddenly, you could see the pain in his eyes because he has not slept in the, maybe yesterday he was not sleeping properly, or maybe you have taken a overtime duty. Now, because of that reasons, his hand got stuck in a machinery. Before even the supervisor, before even he could cry, something happened in such a manner that his hands are lost. Now the employer comes, he's terminating the employee. Now think about his life in the future. Think about his earning capacity in the future. Think about how difficult his family is to survive in the future. So this brings labor laws. You can open your eyes and see. This is the beauty of labor laws. How do you expect people to work overtime? How do you expect people to work without proper helmets? How can you allow a people of different age groups to work on a factory? If it's a hazardous thing without proper facilities, how do you think that a worker is working not under a supervision? So for all these things, we need something called as labor laws. So labor code is actually a law. See, after 20 years or 50 years, you say that our nation is like building, or like we are a developed country. Assume that developed country will have its impact on its labor force. The amount of effort which the labor has put in for this particular thing is going unwritten, unheard. So to counter those things, we are making something called as labor laws. So from the constitution angle itself, constitution, the supreme lawmakers itself, we are trying to say labor is also an important element for building a particular country. That's why labor is given even in concurrent list. Union list, state list, and concurrent list talks about labor laws. So today in this revision, we'll be focusing on that part. If you can actually feel that thing. As I told you, it's something which is not written in ink. It's something which is written in sweat, blood, etc. Because it takes a lot of time, energy to draft something called a labor law, which will come to a balance, which can bring a balance between employer and employee. Employee should not also overdo things. Employer should not also not do things. So it's all of a balancing. So today our marathon will be focused on two parts. One part where we'll be focusing on every prior laws, starting from Constitution, Apprentice Act, Prevention of Sexual Harassment in the Workplace, child and adolescent worker. So those things we'll do as the first part. Then we'll move to the codes. Your labor codes are very, very important for this attempt. So you'll be focused on those important areas of the codes. So probably I'll start from code number 4, 3, 2, 1 kind of thing. So first we'll start with the prior things, which is like unchanged. Those things which are from the scratch. So for that I'll be using again study material For the other part, I'll be using my notes. Again, people who are attending like a marathon, you are free to use your institute material because institute material covers everything. Okay. So now let's start with your constitution and labor laws. Now people, when you start this subject, understand it's going to be the easiest paper which you can expect. But the mindset of the students are in such a manner that company law being the core paper in this first group, it's more of a practical question. Now when you see something called as a straightforward theory question, you find, hey, should I do this? Should I overdo things? So make sure you look for a 5-mark question and you wrap up everything in like 1 page max 1 page or lesser than. Half a page is super good. I would appreciate if you can write for half a page. Now people, to understand your labor laws, it's very important to understand the fact that labor code is we are testing labor code for the students, maybe CA, CS or CM, very first time. So you can expect some good amount of questions from labor code. So it's very important to know a labor code as well as your prior laws. So prior laws, they can ask you, say maybe, what if they ask you 2 questions, 5 into 2, 10 marks. Labor codes put together, they can ask you 30 marks. So put together 40 marks come from prior and post laws. So we'll be focusing on prior laws, 10 marks area. 10 marks probably. I'll expect that. I am expecting 10 marks around prior laws. That too specifically with respect to POSH, Prevention of Sexual Harassment. Now people, Constitution and labor laws. To start with our first chapter, Constitution and labor laws. So Constitution and labor laws, you should be expecting a question like how, like a general question regarding how the Constitution will have an impact on labor code, labor laws. 1. Second question, explain this fundamental rights and how is it impactful in labor. Third point regarding explain all those directive principles of state policy with respect to labor laws. To understand this, Constitution, the first chapter Constitution, where they will have 2 dialogues. They say, India is being a developing nation. First point, on a general question you have to write like this. India is a developing nation which is having a labor surplus and a democratic setup. So, lawmakers should make sure that the law is implemented in such a manner that both employers and employees are equally benefited. That's first part. Now, second bullet point which you have to write for a general question is, sir, labor is an element which is given in concurrent list, meaning both central government and state government will have respective powers to make laws. 2 points. Third point, sir, how is labor laws in the country being governed? It is your preamble of the constitution, which talks about social order. Second thing, your part 3, which is talking about fundamental rights. Part 4, which is talking about directive principles of state policy. So put together these elements help you in making the constitution, will empower or which will direct labor code, labor laws from a constitution angle. This is your first question. Probably when you have to write something on a general parameter, general parlance on constitution and labor laws. Now we'll go to the second part of the chapter which talks about what are the, so one line to start with. Preamble of the constitution highlights the concept of socio-economic justice. So this is one line where you talk about preamble. So one line in the study which talks about preamble, impact of preamble and labor laws. Now, one area. Say for example, sir, my fundamental rights are getting affected. Usually a citizen of India can never go to High Court or Supreme Court. So but whenever your fundamental rights are getting infringed, law article 32 and 226 guarantees a citizen of India to approach your Supreme Court or High Court. So article 32 can be used whenever he is feeling that I should go to a Supreme Court. Article 226 can be used by that person if he wants to go to a High Court. Flip side, there is something called as 136, wherever it's called special leave petition from a decree order of a lower court. You can always make an appeal to the Supreme Court to take the matter into consideration. So 3 things put together are remedies, and we use the name called as writ. WRIT. So you can, if you want, you can write a name of it. It can be mandamus. Mandamus. Habeas corpus. Examples. Just to understand that these are the examples of writ given. Now, second question which they can ask you is, so usually there is an infringement of an individual right. Can he file a case? Yes, he can file a case. Can an employee's representation, meaning a trade union, present a case before court? So first they said no. It's an individual right. How do you think a trade union can represent that thing? Later they reversed the decision, saying that yes, a labor can be represented by its trade unions in a case, in a hearing. So that kind of thing is called, can a trade union move to the High Court under 226? Jaipur Division Irrigation Employees Union versus State of Rajasthan. Simplest. Now let's decode fundamental rights. We have certain fundamental rights to be carefully analyzed, plus some case laws in fundamental rights. So first fundamental, so we don't have every fundamental rights, we have only those fundamental rights which are directly connected to labor laws. So first thing is equality before law. They talk about something like a state shall ensure that there is an equality before law. State means a country shall ensure that there is an equality before law and equal protection of law. So equality, state should treat everyone equally, and whenever there is an issue, equal protection of law should be ensured to every citizen of the country, every person of the country. So this is first para which you have to write in exam. One case law to support your answer. What is that case law? Air India versus Nargesh Mirza, wherein the employer said, hello employee, hello air hostess, you might have to retire from your office on 4 months after your marriage, or in your first pregnancy, or attaining the age of 35. And the employer will have freedom to enhance the ceiling limit to 45. Now this being a scenario where your fundamental rights, equality is being affected, they said no. It's a clear case of violation of fundamental right with respect to equality. So that's 1 point. 1 point under respective case law. Second, so 14, then we have 16. So article numbers are important when you write answers, not section numbers in your code. I don't care about if you remember section numbers or not, but for article, I'll be happy if you can remember the article numbers. Now coming to article 14 then to 16 regarding equality of opportunity with respect to public employment. So law is telling you, we shall ensure, the state shall ensure all citizens are given equal opportunity with respect to public employment. Second, same point, no citizen shall be on the basis of race, caste, sex, religion, etc. to be discriminated on this basis. 2 points. Next 3 points talk about nothing, meaning they are talking about exceptional scenarios. 3 exceptions. Nothing in this provision shall apply to whenever the state is appointing a person with respect to a particular background. When it comes to a law related to a particular state. Example was Jharkhand. So Jharkhand Forest Department, we need a person. We might have to give a preference to a Jharkhand person. These things are allowed. Second point, nothing in this article will be a violation if the state is making a law to uplift the backward people. That's also allowed. Third point, for a religious institution, it's completely fine for the state to bring in a policy wherein they will hire only a person of the particular group only. Okay. So, one case law, Mevaram Kanojia versus All India Institute of Medical Sciences. One case law to support your answer. Mevaram Kanojia versus All India Institute of Medical Sciences. Now, 14, 16, now 19 on C. 19 on C talks about freedom to form association and unions. Even the unions means a group of people. Let's assume company, LLP, partnership, but we should be, from a labor point of view, we will be focusing on trade unions. Now, when I say you have freedom to make a union, that freedom means you have freedom not to join, freedom to exit from the union, or freedom not to join, freedom to continue also. So it's a fundamental right of a person to start a union, get out of union, continue in the union, may or may not join the union. There's something called as All India Bank Employees versus National Industrial Tribunal, wherein they say, I completely understand that you have a freedom to make a trade union who will be representing your rights in a platform, but law is not asking you to do that as such. Try to bring an amicable settlement using your industrial relations code. Not when you write industrial relations code, wherein we are trying to bring an amicable settlement through conciliation process, arbitration process, rather than fighting over through a strike or lockout. 1 point to write. Now, regarding Article 21, regarding no person shall be deprived of his life or liberty except in the procedure laid down by the law. Again, your personal liberty doesn't mean that only the freedom. It will have a freedom to live your life with ease, happiness, no pollution, with dignity also. With dignity is the reason why we have something called as POSH Act. Dignity. So Article 21, we have one case law wherein a person was, what was the case law? Paschim Bengal Khet Mastoor Samiti was a state of West Bengal, where a person fell, where a laborer fell out of a running train and he tried approaching the government department for doing the treatment. Government was not sufficiently equipped to do the treatment. He went for a private clinic and incurred 17,000 rupees. Now law said, yes, it was the duty of the state to provide such facilities. Failure of the state to bring this is a clear violation of Article 21. Correct? 21. 21A. 21? 19(1)(c) and 21. People then 19(1)(c), 21. 19(1)(c), now it's 21. Now Article 23 and 24. 23 talks about state shall prevent trafficking in human beings, beggar and other similar forms of forced labor. So you are asking him to work with a lesser amount or asking him to work without a payment also is amount to forced labor or like a beggar. So that we have a case law called Sooraj vs State of Madhya Pradesh, wherein a person is being given not a salary and asked to work. So this is also clear infringement. That's why we have couple of case laws, couple of laws coming under this code, wherein we talked about minimum wages, payment of wages act, etc. Now, last part of this chapter talks about labor laws and the references to directive principles of state policy. So here we are going to learn one case law. Remaining everything is regarding what are the different directive principles of state policy which you know. So different directive principles of state policy will have an impact on labor laws. One of that is 38. We start with 38.1. States shall strive to. So I want you to remember at least 4 or 5 with the language. So 38, so they won't ask you specifically, mostly they won't ask a specific point. Generally, what are the fundamental, directive principles of state policy and its impact on labor laws. So Article 38.1, states shall strive to promote the welfare of people by securing and protecting us effectively by social order. So they are trying to ensure a justice through social, economic or political. So justice should be ensured. So this is an initiative to be taken from the government angle to bring a policy which will ensure we are here to promote the justice. How? What justice, sir? It can be social, economic or political justice. Now, states shall try to eliminate all inequality with respect to status, facilities, etc. Try to remove inequalities. 39 important, where you have equal pay for equal work. Again, we have to note under your labor code, which is only on same work or work of similar nature, where your effort, skill and responsibility and experience is something which matters. That you have to remember. So otherwise, all citizens, irrespective of, so people here discrimination, we are talking only about gender, because here Article 16 we talk about some discrimination, fundamental rights, it's regarding race, religion, etc. Here we are talking only on gender. So all citizens, irrespective of sex, equally have the right to adequate means of livelihood. that ownership and control of material resources of the community are to be distributed. That's why ration shops are there. We are distributing everything equally among people. You should ensure there is no monopoly being created. So they are using the word operation of your economic system does not result in concentration of wealth and means of production of common detriment. There is equal work for both men and women. Health, strength of workers, men or women, tender age of children are not abused. That's why prohibition of child labor, occupational safety code, which will talk about how safety and equipment should be employed in a factory. Now, children should be given opportunity to develop his youth, free from exploitation, etc. So equal pay for equal work. Okay. Now, one case law to support our answer was, okay. Social security provisions. Social security, we have a social security code. Along after employment, or if there is an unemployment for unorganized sector, we have seen some schemes which will help the poor. So those kind of social security norms are also in an establishment. Should be in an establishment. Should be in the country. Working conditions. Occupational safety code talks about having a better working condition at the workplace. So Article 42 requests the state to make a provision for securing just and human conditions of work. Living wage, minimum wages, payment of wages act. The state shall secure by suitable laws, suitable legislation, that all workers, agricultural, industrial, otherwise, should be giving a living wage or conditions of work. So living wage and conditions of work should be given to all those people. That's why we have living wage, a particular point. Workers' participation management. Different committees across the code will have employees also participating in the committees. This is one particular norms given as per your directive principles of state policy. One case law to support your answer is Janapa Reddy, Surya Narayan and others, wherein a part-time worker or a contractor worker is given a work for a full time, benefits which is given to the normal worker should also be extended to such person. So also a policy wherein states should frame policies in which they will ensure that people are being protected. So put together is your constitutional labor laws. A easy concept to learn, easy concept to score as well. So probably a question from this part. So I go with it. My inner instinct says one question between constitution and other parts. First part le POSH on mandatory question. Remaining chapters, let it be apprentice, let it be like a child and adolescent worker, let it be your constitution, one question. Put together your 10 marks. One question, probably. I'm expecting a question from POSH. Second question from all these chapters put together. Remaining 30 marks, say for example you have 6 into 5, 30, 6 questions from labor codes. That's what I'm expecting. So that's first chapter. Okay. So people just go through your constitution topics, see if everything is okay, under control. Constitution and labor laws. Okay, people. Next topic we will be doing POSH Act, Prevention of Sexual Harassment in the Workplace. So, people, another important chapter, POSH Act. People, you have to remember first question regarding they can ask you the what is the outcome of Vishaka judgment or what is sexual harassment as per this law. First question. So both you have the same answer called as the points. So Vishaka judgment talks about prevention of sexual harassment, which says sexual harassment includes such unwelcome sexually determined behavior such as physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography or any other unwelcome physical, verbal, non-verbal conduct of sexual nature. First likely question is regarding how do you deal with this thing? Vishaka judgment, its outcome, or what is sexual harassment as per POSH Act? First question, very easy topic. Now you have to see how this particular chapter is regulating sexual harassment in workplace. So, people, they can ask you what are the types of sexual harassment. Types of sexual harassment can be a quid pro quo, like you are saying, I'll give you a preferential treatment. You do a sexual favor, I'll do a preferential treatment, more bonus, more gratuity, or hostile working environment, detrimental, negatively. If you don't do such sexual favors, I'll kill you. I'll make your working life horrible. Those kind of things can be your sexual harassment. So sexual harassment can be positively. When you say positive means like a positive reward, like your quid pro quo, or a negative reward where you create a hostile working environment. Now, you should know the definition of aggrieved person, because it's a aggrieved person and the respondent. Two people are talking about an aggrieved, affected lady and a respondent, who is the person who has done that particular sexual harassment. So, aggrieved woman can be two things. One, if she is working in a residential place, dwelling place, a woman of any age, or in a workplace, any age, whether employed or not. So whether she is employed in that particular industry or not, that can be an aggrieved. Meaning a customer coming to that place got a sexual harassment, also this provision will trigger. Second point, in relation to a dwelling house, a woman of any age employed in such particular house for household thing. Two people. Now, people, next question they can ask you is, what do you mean by workplace? Workplace as per. So the law is talking about prevention of sexual harassment at workplace. They can ask you workplace as well as extension of the workplace. So you need to know a case law called as Saurav Kumar Malik versus Comptroller Auditor General, wherein there is a sexual harassment reported against a senior employee and happened as an official mess. So the question was regarding whether official mess should be called as a workplace, because sexual harassment at the workplace. Now law said, okay, generally these are workplace. What sir? Workplace include department, organization, undertakings, establishment of the private people or as well as the government. Private people, government sector, you have a establishment, enterprise, etc. That is a workplace. Hospital, nursing houses are also workplaces. Sports stadiums, game venues are also work. Transportation, commuting, that is also workstation. A dwelling place is also a workplace. And so these places can be called as workplace. A sexual harassment that this place can be under this purview of the act. Again, they have added based on a case law on something called as extension of that law, where you can prove that proximity from work, from place of work, proximity, very near, or whether the management is having control over that place, or that is an extension or contiguous part of your working place, this particular place which is an extension of your factory or a canteen of your factory can also be covered under the purview of workplace based on the case law. So they can ask you workplace and extension of workplace or a practical question. This happened at a so and so place. So any place you tell, you write this because the question will be focused on whether this is called as a workplace or not. So general workplace and extension of workplace based on 3 principles and a case law. Easy? Now, so how is the law regulating such thing? Now regulation. Law says, assume that there is a sexual harassment happening at an industry where more than 10 people are employed. Okay. Now, every organization having 10 or more employees should have an internal complaints committee. So whenever there is an issue, you file a case under that internal complaints committee. So what if I am in an unorganized sector? Unorganized sector. Or, important, you are going to file a case against the employer who is in charge of the internal complaints committee. Now the committee will not take the case seriously. So law is telling you, whenever you are reporting a sexual harassment in an unorganized sector, or whenever you are reporting a case against the employer directly, you should not go directly to internal complaints committee. You should go to a local complaints committee. Now, for a company inside, you should have an internal complaints committee. So, every employer should have an internal complaints committee. Then, first question, what should be the composition of that internal complaints committee within your organization? It should have a presiding officer, should be a women employee, senior women employee of your company. If she is not there, go to some other establishment, get her. Second, members, not less than 2 members, having a social work or having legal knowledge. Then an external member should be a non-governmental organization. So there are 4 people. 1, a presiding officer, senior most employee of your organization. Second, members, not less than 2, should be having experience in social work or legal background. External member, who is from like a non-governmental organization. Now, tenure should be 3 years. External member alone will be paying fees. Others are part of your organization. When the person is contravening the provisions of the law or convicted for an offence, found guilty or has abused a position, that will end up in his casual vacancy. We have to throw him away. Now, easy point, you have to remember the committee parts. Local complaints committee. When sir, unorganized sector files cases against employer, third party who is not an employee. These scenarios, at every district level, we should have a local complaints committee. So, this should be done by a district magistrate or additional district collector. So, it's on a district level. So, usually a collector or district magistrate will be the head of that thing. Composition, it's not presiding office, it's called chairperson. Eminent women of social worker committed to cause of women. 1 member among the women in block, taluka, etc. 2 members, one shall be nominated from non-government thing, preferably having knowledge of law or legal knowledge. Now, 1 person from SC/ST and social welfare or women or child development in district office shall be the ex officio. Ex officio, meaning who is holding that position should be part of your committee. Now again, same points will incur a casual vacancy. So you have to be careful. Presiding officer here chairperson. Committee and its local committee and internal complaints committee. Who are the people inside that? Can be a question. Difference between those two. Now let's go with complaint. So they can ask you complaint also. What is a complaint? An aggrieved woman writing a complaint of sexual harassment to the internal complaints committee or local complaints committee, as the case may be, within 3 months of the incident or 3 months from the date of last occurrence. Repeat incidents. Now, if she is not in a position to write that thing, the team, the internal complaints committee or local complaints committee shall offer her assistance to write that, finish the complaint. Now, because of her mental state or something, or physical health, she is not even in a position to do, then there can be her legal heirs also, legal representative also helping her to file the complaint. Sir, what if she is not filing a case within 3 months? Again, you can extend for another 3 months also. Now, when you're writing a complaint, the complaint should say relevant dates, timing, location, name of the respondents, and the working relation between these two people. This should be part of your complaint. Now, when I say the purpose of this law is not to fight, purpose is to have an amicable settlement. So before you plan something called as inquiry proceedings, better to do it in amicable terms. So let's go with something called as conciliation, amicable settlement, peaceful settlement. So internal committee or local committee, as the case may be, may initiate a conciliation at the request of the girl. So agreed woman should request, it's not the other party. So if both of the parties are okay, they can end up with a conciliation, they will come with a settlement. Happy. Again, conciliation should not be monetary. Your outcome should not be like, I'll pay you 1 lakh rupees if you stay silent. That should not be your part. It can be apology letter, it can be asking him to go to some other, or night shifts can be balanced, or shift can be balanced, working hours can be balanced.
It cannot be promoting like agreed promotion, right?
Promoting the?
Agreed promotion, they can't give promotion.
Promotion in the job.
I know, that's not a right way to deal. No? Monetary means like instead of that you will get money.
So instead of that, they can promote.
Then how do you think it's a remedy? Now, once a settlement is done, the respective local committee will forward that to magistrate. If it's internal complaints committee, should forward that same to the employer. Now, if this issue is so serious, or the person is after the settlement is not okay with the settlement, then the issue will be, the gravity is more high. You will go into the second stage where you have will go with the proceedings. So first thing is inquiry. Now they will go sit with the inquiry. What happened really? They will try to figure out. Maybe because so previously settlement happened because both parties are okay. The other person is admitting his fault. Now what if the other person is not admitting the fault? You should always go with an inquiry. Come with the climax. Now. Okay. Action during your inquiry. During the inquiry, on the request given by agreed woman, she can be transferred to some other workplace, can be given a leave up to 3 months, or some other relief as the law may prescribe. You can do that. Now, this particular committee shall give its inquiry report to the concerned employer or the magistrate as the case may be. So you are forwarding that to local committee or internal complaints committee will forward to the respective people, employer or district thing. They will keep this mind and they will have. So if it is not proven, dismiss the case. If it's proven, the case is against the person affected is an employee, worker, employee. Both are employees. Think about the service rules. Do the things as per the service rules. Nothing is prescribed, go with the law. What is given in POSH Act, you have to do. Now, how will I do this? I will be deducting. This was our exam question. Okay. So, what do? You deduct the salary and pay to her. So, you keep from your salary, you can claim the compensation. Now, understand, settlementally, you don't have a monetary compensation, but after an inquiry report, you will ask you to pay a fine, penalty. That's why there's a monetary punishment happening after an inquiry report. Now, sir, what if you are making a malicious complaint or false evidence? You are making a fake complaint or producing a fake document, or someone else, you are a witness to that thing. You have produced a fake witness. Those things you will have to be dealt with service rules. If no service rules, ask for the law. Now, how do the authorities derive at a compensation? They will see the following parameters: mental trauma of the agreed woman, loss in her career opportunity, medical expense incurred by the victim, income and financial status of the respondent, feasibility of paying in lump sum payment or not. So 3 parameters with respect to the agreement, 2 parameters with respect to the respondent. Put together, they will come with a determining how much compensation you have to pay. Now, important question. Notwithstanding anything contained under RTA, all those stories, details of inquiry, details of conciliation, nothing should be revealed to a person. So even if it's Right to Information Act gives you power, if you ask this thing, I am supposed to say no, I won't be able to give. I can say I have a freedom to reject. Now, for without disclosing the details of the employee or victim, what I can do, I can give an information for a research purpose, etc. That is allowed. Otherwise, don't do that. So, duties of employer, ensure that. So, again, a 5-mark question. Provide a safe working environment at the workplace, including safety of people coming into the workplace, maybe even for the customers. Display at a conspicuous place regarding the consequence of sexual harassment. Include this thing part of your service rule. That if you do this thing, you will be having that. Provide necessary facilities for internal complaints committee or local committee to take investigations. Assist in securing or bringing the respondent or witness to that committees. Make available information to that thing, to the committees. When the agreement is asking that I should go with a police case only, police case, outcome can be police case, you can provide assistance to that. Miscellaneous. Submitting an annual report is part of your obligation. Again, company related question. Your board's report, one of the content is disclosure of sexual harassment. And sexual harassment which is remain unsolved for more than 90 days should be part of your board's report. Can be a content question under your annual report topic. Okay. Act not in derogation of any other law. Meaning, just because you have been saved, inquiry report is in favor, doesn't mean that the other person cannot file a case in court. Those two things are operating differently. Just because you save yourself from a problem with respect to sexual harassment in your internal complaints committee meeting doesn't mean that you are saved. The agreement is having all the rights to file a case before a court. On case law, what was the case law? That's derogation. Yes. Vinod Jacob versus State of Kerala regarding the derogation thing. Raila Satyanarayana versus SBA Mutual Fund also regarding committee's outcome should not be a conclusive evidence. You have to terminate that employee. You have to again see what is given in service rules. Then only you have to terminate it. Easy points. You are able to recollect things? Good. In the first part we have 3 more chapters. Then we will take a break. Go with the codes. Online you are able to recollect things. Kind of brushing up. Good. Okay. So, people, very small topic. Labor laws, simplification of procedure for furnishing returns and maintaining registers. Easy topic. People, law is telling you, so this has direct connection with the previous laws. Previously, assume that I am an employer, I fall under all the laws. All the laws. Assume that there are 25 laws. Then 25 laws come, 25 laws. For all the 25 laws, you might be required to keep a register. All the 25 laws, you might have to be asked to file annual return. Now this became challenging for small establishment. So law is giving you an exception. A small establishment or a very small establishment need not maintain registers separately for all the laws or need not file return regarding all the laws. You do a summarized annual return or summarized register, that is completely fine. So this chapter is very easy, maybe a 2 minute revision wherein they talk about this thing. So what is an small establishment?
More than 10, 10 or more, but below
10 to 40 is your small establishment. Up to 9 is your very small establishment. All these people, for these 16 laws, you need not produce separate registers, separate returns. Instead, do this thing. Every establishment, people small, very small, should maintain annual return, should file annual return form 1, mandatory. Form 1 is mandatory for very small as well as small establishment. Then form 2 and 3 mandatory for small establishment. Form 3 only mandatory for very small establishment. Very small. Small establishment. So small establishment 1, 2 and 3. Very small establishment 1 and 3. 1 and 3. What is 2 and 3 da?
Employment card, muster roll.
Employment card and muster roll. Now, along with this thing, you have to maintain 4 more details. 1, wage slips. Slips regarding measurement. Accident report at a factory or plantation. Easy. Done with the chapter. Very small chapter. There are a couple of laws. That couple of laws, you need small establishment, you need to file separately or maintain separate register. Instead, do a summary. That's completely fine. Okay. Easy topic. Yes, sir. Da? Okay. Tambi. Two more chapters. Okay. People, child and adolescent worker, Prohibition and Regulation Act. So, 3 questions they can ask you. People, child labor to be prohibited. We are going to prohibit child labor and regulating adolescent worker. Prohibition of child labor and regulation of adolescent labor. So who is a child? Adolescent was not completed 14 years. 14 to 15, 14 to 18 is called adolescent. So how are the laws going to regulate or prohibit the conditions working of these people? The first point is prohibition. People, prohibition. No child shall be employed or permitted to work in any occupation or process. So child is not allowed to work in any occupation or process except helping his family other than hazardous occupation after his school hours or during vacation. Or he can part as an artist other than circus. However, no work shall affect the education of the child. So no prohibition. Easy point. Now, okay sir, how is the law regulating adolescent? Child no work sir, adolescent allowed. Sir, allowed only for non-hazardous. So law is telling you, we are prohibiting you. It's actually a regulation because we are prohibiting you for only these activities. What are those activities? Mines, inflammable substance, hazardous process. Done. Easy chapter. One more point. Sir, tell me how the time slot of these people are controlled. One. They are telling you adolescent worker, not the child. Child, no, nothing is given because child can work at any point of time. Only those allowed areas. Adolescent worker should not be allowed to work more than 3 hours. 3 hours unless given a day 1 hour of rest. So 3 hours, then 1 hour break, and put together the total spread over shall not be more than 6 hours. Now, extra 3 points, not allowed to work between 7 p.m. and 8 a.m. No overtime, no double employment. Done. All those weekly holidays, everything should be like a one holiday for the weekly holiday, and blah blah blah. Yes.
So this one was cannot be altered more than this one.
Cannot be altered.
It cannot be altered more than once in 3 months.
Okay. Shift.
Ah.
Starting at one thing and going to some other plan. Okay. Okay. Done with the chapter. Last chapter in the first part is regarding Apprentice Act. People, Apprentice Act. So apprentice is a person who's going. So friends, moving, painting. Apprentice is a person who's undergoing apprenticeship training as part of their contract of apprentice. Okay, good. Sir, you are talking about designated trade because it's important to start with the chapter. Designated trade means any trade or occupation, engineering, non-engineering, vocational, anything which you do after consulting with Central Apprenticeship Council. So there's someone called a Central Apprenticeship Council, one authority. Now there's something called graduate apprentice who has completed his degree. There is a vocational apprentice who has completed 2 years of that after 12th. You have done some kind after 10th standard. You have done some 2 years of vocational course. An apprentice means any person who is doing a designated. Any designated you are doing, we call it as a trade apprentice. Trade apprentice doing any kind of designated trade. Now, first question. What are the qualifications for being appointed as an apprentice? So, no person shall be allowed to be working as an apprentice. So, no less than 14 years or hazardous 18 years. Hazardous 18, normal scenario 14. Then he should meet all those standards of education and physical. So, physical fitness and education standards should be met. Then, next question they can ask you is, what is a contract of apprenticeship? Before enrolling yourself for doing the work of an apprentice, you should enter into a contract with an employer. You, or if you are a minor, your guardian should enter into a contract with the employer. It is deemed to be effective on the day in which the contract is entered. So from the date of the contract, the apprenticeship training actually starts. Every apprenticeship contract will have terms and conditions. You have to send the copy of your contract within 30 days to the apprenticeship advisor. Apprenticeship advisor may give any objection. If not, he will register the apprenticeship agreement within a period of 30 days of the receipt of your application. Then, contract of apprenticeship. Easy points. What is novation? The novation, change in the employer to continue the remaining part of the contract. The remaining part of the contract, some kind of, so you entered in with an employer for 1 year contract. After 6 months, your family is shifting to some other place. Remaining 4 months of training can be undertaken with the same terms and conditions at a different employer. You're just changing the employer. It's actually a alteration of contract with the change of party. We call it as novation. Now, so period of apprenticeship training. People, 4 points. Answer is simple. As may be prescribed. 4 points. As may be prescribed. First point. Sir, I am a trade apprentice. I have undergone institutional training at National Council and has undertaken trade test examination conducted by that National Council. They will prescribe what is my period of training. Sir, what if I am a trade apprentice? I have already undergone institutional training. Very important. Institutional training already done. That's why the point of next topic, basic training. So, you have done institutional training with the state government and passed all those tests etc. Then they will decide what is your training period. Third point, other trade apprentice as may be prescribed. In case of graduate or technician or like a vocational apprentice, as may be prescribed. So your law starts like this. Sir, I have to do a training under an employer. You should have done institutional training. To start with your, so the training, the apprenticeship training which we are going to talk is called practical training. Practical training. Before the practical training even commences, make sure you are a good citizen. What is a good person, sir? You have already taken a institutional training under national or state level. Okay. That's how we are. Now, let's go with other part. Sir, practical and basic training. So people, to start with, understand, here we are talking about practical training. To reach a practical training, you should have already undertaken institutional training with the central or state people. So what if I have missed my institutional training? Then employer, before giving a practical training, do a basic training. So this can be only, I am doing only practical training with the employer or basic training and practical training with the employer because I have already undertaken an institutional training with the authorities. Now, first point, practical and basic training. Every employer shall make suitable arrangement in his workplace imparting a course of practical training to all those apprentices. Employers duty to make a suitable arrangement in the workplace for having practical training. The central apprenticeship advisor or state apprenticeship advisor shall be given. So people who have taken basic institutional training under them, and I am giving them practical training. I should give them opportunity whenever they want. They can come and check how their students are reacting. I should be given equal opportunity for those authorities to come check how their students, their products are performing in my office. Now, third point. Such a trade apprentice not undergone a institutional training under national or state council should do a basic training before you start your practical training. Sir, in case of apprentice, all those syllabus, practical, basic training, syllabus and equipments shall be approved by authority, central government in consultation with Central Apprenticeship Council. Now, people, cost. Very important, tricky question. There are two types of cost: normal cost, recurring cost, including or excluding stipend. So they are telling you, first, in case of a trade apprentice, people, trade apprentice, then not undergone institutional training. 1 second. Okay. So there's a trade apprentice not undergone your institutional training, then recurring cost including the stipend should be borne by
In case of more than 250,
up to 250. It should be borne by
both sides.
both employer and central government. If the number of employees are more than 250, should be borne by employee alone. Employer alone. Now, I am doing practical training, then and I have already completed your institution training, everything cost should be incurred by employer. Now, recurring cost excluding the cost of stipend for a trade or for a graduate or vocational apprentice should be borne by employer. Cost of stipend should be borne by central government. Okay. Let's decode this one more time. Sir, first 2 points. Trade apprentice. I have already completed institutional training. Now, already completed institutional training, then the entire cost, including stipend, cost plus stipend, is purely based on number of workers. Up to 250 workers, central government as well as you can contribute. You means employer can contribute. More than 250 workers, only the employer should only contribute. Now, not undergone institution training. Not undergone institution training. Not major training should be given. Now, otherwise, everything should be made by employer. For a graduate or occasional apprentice, then it's like recurring cost separately, stipend separately. Stipend, central government and you, employer equally. Cost or other expense should be employer pocket. Easy? So this should be a confusing part. Only confusing part in first part is this one, on how to determine the amount, cost, etc. Now last part, obligation of both employers and employees. Correct? Okay. Obligation of employer provide apprentice with training in his trade. If he himself is not qualified, ensure people are good enough to train him. Provide adequate instructional staff to the trainee. Carry out other obligation as per the contract of apprenticeship. What is your obligation? Learn your trade consciously, diligently, and try to come out as a good company secretary. Attend practical and instruction classes carefully. Carry out all the orders given by the employer or seniors. Carry out obligation under the apprenticeship. But if you are a graduate or technician apprentice, try to do more research. Try to learn a subject skill more. You do your own research because you are already a degree student. Now, working hours, overtime, etc. Weekly hours and daily hours of apprentice shall be determined by the employer. No apprentice shall be asked to work overtime except after the approval of apprentice advisor whether the overtime is actually beneficial for the employee or the public interest. Fire engine example. An apprentice shall be entitled to such leave and holidays as the case may be. Okay. Holding of test and grant of certificate. You have to do a test. National Council should do a test and grant them a certificate of fitness. Yes, you are qualified. Now, if the contract says you have to offer, you have to. Okay, so it's like a mandatory thing on the part of employer to offer, or when he is requesting, give him employment after the training period is over. They can ask you 2 more questions if not possible. Authorities under this Act: National Council, Central Apprenticeship Council, State Council, State Apprenticeship Council, All India Council, Regional Boards, Board of State Council of Technical Education, blah blah blah. So these are the things which will come as authorities under this particular Act. Easy. First part is okay. Now we have 4 more chapters, 4 tiny codes, separate codes. So we'll take a break now. Go enjoy next 25 minutes. Come back. Okay. So make sure it's done. Relax. Don't read anything. Come back after 25 minutes. Online okay? Better? You're able to recollect things? Let's decode. The second part of the marathon is all about all the 4 codes. So we need to discuss different codes. First code which I am going to discuss is Social Security Code. People, Social Security Code. People, Social Security Code is like, assume that there is a worker employed under you. So the labor law, second part is regarding all the 4 code. One of the code is Social Security Code, wherein a worker is employed under you. What if he meets with an accident? And he is going to go out of the organization. Should I give him some compensation? Oh, sir, no, sir. I retired after attaining 58 years. Should I give him some compensation? Okay, sir. Then, sir, what about PF? So, what if I got a occupational disease when I am working within the organization? Will the employer take care of that thing? So, all those welfare, or sir, I am on my maternity leave. Whether I will be paid on during my maternity, can I ask him to give me a comparatively lesser job framework? All these answers, which is for social welfare, is answered under Social Welfare Code. So Social Welfare Code will have different segments: EPF segment, ESI segment, Maternity Benefit segment, Gratuity segment, other occupational diseases and compensation related thereto, and for unorganized sector. So put together, these are the areas to be discussed on a priority basis. Okay, concentrate. So first point which I am going to discuss is on applicability. So people, any establishment is having 20 or more employees, PF related process will trigger. So employees Provident Fund points will trigger on every establishment having 20 or more workers. Remaining everything, say for example ESI, maternity benefit, everything covers 10 people. So when the establishment having 20 or more people, PF provisions will trigger. Remaining every provisions applicability happens when your establishment is having 10 or more people working under you. Again, even if it's not applicable, you can voluntarily, with your majority of employees and employer's permission, you can go with the voluntary applicability of the provisions as well. Okay. Now, we'll go with the EPF provisions. People, a few definitions which you have to keep in mind is people, aggregator. The impact of aggregator is because your last part which talks about gig workers, Uber, Ola, etc. The provider who is going to connect the customer with the cab driver is called Uber. So that person is called aggregator. Or a person who is connecting the particular place where you can watch films. You can watch a film somewhere. So somewhere I had watched films. A PVR, you are going to watch films. So how are you getting registered through a book my show? That particular providers are called aggregators. Okay. Now, people, confinement with respect to your Maternity Benefit Act can be a labor resulting in a living child or labor after 26 weeks of pregnancy, either whether the child is born alive or not. People, whenever the law is using the word employment injury, the term shall include a personal injury caused to an employee caused by accident or occupational disease. So, when I say accident or occupational disease which is arising out and in the course of employment can be named as common as employment injury. So employment injury includes both accident as well as occupational disease. Okay. Permanent partial disablement, where the disablement is of a permanent nature that reduces the earning capacity of an employee in every establishment which he is capable of under. So permanent partial disablement, because we have to see how much percentage of compensation I will get, 60%, 50% and all. So that's why we have permanent partial disablement, permanent total disablement. They will not ask you what is permanent total, what is permanent, but understand there are words called as permanent partial, permanent total, and there is something called as temporary disablement as well. Temporary disablement as well. Seasonal worker, some seasonal factory which is not working more than 7 months in a calendar year. Superannuation means you are going out of office after reaching 58 years. Temporary disablement, temporarily capable because of some occupational disease or injury, temporarily disabled, temporarily you are not able to work. Okay. So let me go with the different. So okay. First let me go with EPF. EPF. So first kind of social security is called Employees Provident Fund. Employees Provident Fund. So central government appoint Central Provident Fund Commissioner. So first authority in this particular chapter is called Central Provident Fund Commissioner. You can have additional deputy, regional, etc. You can have additional people to support your work. When you are hiring, you should consult with UPSC when you hire people for this particular grade. Now let's talk about schemes. In a PF, you have 3 types of schemes. One scheme called as Employees Provident Fund Scheme, Employees Pension Scheme, and EDLI, Employees Deposit Linked Insurance Scheme. For a EPF provision, we have Employees Provident Fund Scheme, Pension Fund Scheme, Employees Pension Scheme, Employees Deposit Linked Insurance Scheme, and for self-employed people, unorganized sector, government is free to determine their own schemes. Government is free to modify or add or delete schemes as may be possible. First point regarding schemes. Now second expected question is regarding contribution. For a EPF protection, both employer and employee should contribute. Sir, how much I should contribute? We are talking about employee angle. 10% of your amount, wages, should be contributed every month as a PF contribution. Employer is also supposed to contribute 10%. Sir, meaning even though the code is talking about 3 elements, EPF, pension and EDLI, we said contribution should be made equally. Again, law is telling you 10%, when I say 10% should be contributed only by employee, and employee's contribution directly 10% moves only to PF. And the law says employer should also equally contribute. So again, employer should contribute 10%, but that 10% goes like this. Hence, PF in employee is contributing 10%. I will contribute only 1 point something, 1.67 in that. 8.33 I should put in pension. So employer contribution 10%, 8.33 will be given to pension, and 1.67 will only go for PF. And again, he should extract 1% for EDLI scheme, including the administration fees. 1/4. So employee's contribution 10% will move to only PF. Employer contribution 10% will move 8.33 to pension, 1.67 to PF, and extra 1% and administration costs will be given to the EDLI scheme. Okay. EPF provisions are not applicable to cooperative societies where less than 50 people are working without the aid of power, government establishment, other statutory establishment, existing beneficiary, meaning you are already covered under PF law, PF code will not cover you people. Sir, can I transfer account? Sir, I am in a establishment where PF provisions were not applicable. I am switching to a provision, to an establishment where PF provisions are applicable. Can I carry forward all those balance? 100% you can carry forward. So I am working in an organization where PF provisions are not applicable. Again, but I have done voluntary contribution. Then also accumulated balance in that PF can be carry forwarded. Okay, so PF, we have seen PF basic provisions on PF as well as your contribution part. For ESI, you should stick on with 3 key points. 1, general conditions with respect to medical treatment. What are the expenses to be incurred by ESI corporation? What are the medical benefits you as an employee, insured person or a dependent can get? Okay. So first point, our syllabus is not covering about how much contribution, so we are safe. We are safe on that part, contribution on ESI. First likely question, purposes for which ESI fund can be used. So ESI is a employee state insurance where when you are having a medical emergency, you can go approach as a hospital. Now ESI will have funds. What are the purposes for which ESI funds can be utilized? Point number 1. To give medical benefits. So medical benefits to the insured person or their family or dependent person, you need this particular ESI fund. ESI fund can be utilized. ESI fund can be utilized for the governance cost. You have 2 committees here. One is a medical benefit committee and standing committee. These committee will have office bearers. To pay them, you should need money. The money can be taken from ESI. Third, all those employees working under those council, those committees, those committee members of the payment, not about employee, our employees, we can pay. To start more hospitals, more clinics, so that employees can get access to the hospitals. To create such kind of environment, you can use that ESI cost. ESI can be given to external person. Say for example, some other private hospital you have taken medical expense. I can reimburse that thing. That payment also is part of your ESI's expenditure. ESI will have, being a government department, will have to undergo an audit. That audit fee should be done. Now one person lost his job, is trying to rehabilitate. The rehabilitation can be undertaken by ESI. That is also a cost of ESI. ESI cost. ESI authorities cost. Now, second question. Sir, what are the benefits a person will get? So what are the benefits an insured person or a dependent or family will get? 1. Sickness benefit. You'll get cash benefits during your sickness. Maternity benefit. So now again remember, when you are claiming, so ESI also will cover maternity benefit, Maternity Act will also cover. But you have already seen you have a freedom to choose. Which is more beneficial, you can choose. Disablement benefit. Disabled, you can get benefit out of that. Payment during disablement. Dependence benefits. Dependent also at times you will get benefits. Medical benefit and funeral expense given to the eldest surviving family member must be claimed within 3 months of the death. Okay. People again, accidents which is happening with the breach of law also you can claim compensation. In breach of law. Example, driver, Swiggy, helmet. Don't think about that. Action happening within the organization. Breach of law is general law breach. So a Swiggy driver was asked to deliver, but he took a one way, police caught him and met with an accident. So met with an accident at the wrong way, Again, employer has to comment this because it's part of his job. Okay. People, third important point is regarding general provisions as to benefits. What are the general provisions as respect to benefits under the scheme? 1. People, you cannot have a lump sum consideration, lump sum conversion. Lump sum conversion is permitted subject to the other part of the law. After completing 6 months, you may claim a lump sum thing. No benefit during the period in which you have taken a leave. Leave time, it's your, like say for on a strike, you are sick, you cannot claim that. On an Independence Day, you are sick, you cannot claim that benefit. So second rule is regarding no benefit during a holiday. On a leave vacation day, you will not claim. Now, the third point is general duty is make sure you are going to the treatment which is provided by the authority. Follow stricter medical instructions, not to leave the treatment area without approval. Follow all those instructions given by the authorized doctors. Now, if you are having multiple benefits and a multiple code, you can choose which is beneficial for you. After death, the benefits can be given to the nominated person or legal representative. No double employment from employer. Wrong payments, you got a wrong payment, employer is free to recover that amount. There should be the competent authority will sit and decide what is your non-cash benefits. Now, corporation can also fight against you when you fail to insure an employee or register a case of accident or even fail to pay contribution. These can be a ground for which employer can be filed. A case can be filed against employer by the authorities. Now, these are the three elements with important elements with respect to your ESIC. Third point is regarding gratuity. Again, important point. So gratuity will be given to an employee who has rendered continuous service of 5 years. For a fixed term employee, it should be 1 year. So what is continuous service? Continuous service, continuous service means a service is not interrupted, even if it's interrupted due to sickness, disablement, etc. So you have to go back and see the definition part, disablement, etc. Now, person shall be deemed to be in continuous service if he is working in a mine or an establishment where it is less than 6 days work. Then he should have been employed for minimum period of 180 days in case of a whole year computation, 95 days in case of half year computation. But in case of a normal industry, it should be 240 days in a normal scenario. For a 6 months computation, it should be 180. So why is it 6 months and all? Because gratuity, when you pay based on completed year of service and half month period, excess of 6 months. You are getting a payment which is in excess of 6 months also covered. So how will I know he is working? It's based on these numbers. So calculation of gratuity is based on 15 divided by last drawn salary into 15 divided by 26 into completed year of service or part in next 6 months. That's why 6 months calculation and whole year computation, you should be knowing the numbers. Now, so people, this point, continuous service means a service which is uninterrupted, even if it's interrupted due to sickness and all. So meaning, I worked sir, but I took a leave of maternity for 2 weeks. That is also presumed to be in uninterrupted service only. Now, law presumes to be in continuous service when, for a period of 1 year, you should be working minimum 240 days normally. For a half year period, you should be working minimum of 120 days. For a mines and all, For a yearly period, you should be working for a minimum period of 190, and for a 6 months period, you should be working for 95 days. Nomination. Once you have completed 1 year, you can nominate a person. Nominee should be part of your family. If you are not having a family, get married, find a family.
What is family? You have to change.
You have to change. Payment procedure. Employee applies in writing to the employer for gratuity. Employer calculates the amount and communicate the same to the both employee and the competent authority. Payment must be made within 30 days of being payable. Delayed payment is subject to an interest. Dispute regarding the gratuity amount shall be decided by the competent authority. Now, you are having more than 500 employees in your organization, and if you are having an approved gratuity fund, then you need to create an insurance. If not, you should have a mandatory insurance, so that in case during the gratuity maturity period you are not having a balance to pay also, insurance company will take care of that.
Then they'll claim.
Now, done with gratuity. Easy point. Gratuity can be a question, good question, solid question. Now, sir, gratuity is done. What about Maternity Benefit Act? Again, important chapter. Maternity benefit will revolve around 3 points. No employee shall be allowed, permitted to work, or you, a women employee, you cannot ask for work 6 weeks immediately after your delivery, miscarriage, or medical termination of pregnancy. Okay. Now, but during this period or 1 month prior to the date of your break, termination, you on request given by the women, the employer should provide her konjam lenient work, like not to do an arduous work, not to do a work which will affect her childbirth. So make sure that's done. First point was regarding not to allow the person during that 6 months period, 6 weeks period, and she should also initiate working 6 weeks immediately after the 3 wordings: delivery, miscarriage, or medical termination of pregnancy. Now, she is entitled to claim a maternity benefit provided she has worked for the employer with how many days? 80 days. 80 days. Now, how much benefit I will get? They are telling you, you will get 26 weeks of paid leave. So, paid leave can be taken in such a manner that prior cannot be more than 8 weeks. So, you can take 26 weeks after your birth, childbirth. Or prior means, prior 26 is not allowed. Prior can be only 8 weeks. So, prior you are taking 8, post is what? 18 more months. Put together 26 weeks. So, what if I am a mother of already 2 kids? It's my 3rd pregnancy. Then you can take a leave, earned leave, or a paid maternity leave of total of 12 weeks. That too, prior period cannot be more than 6 weeks. Before delivery. Okay. Okay. Adoptive or commissioning mother can also avail this for a period of 12 weeks. Provided 12 weeks, provided the child is less than 3 months. Employers may allow work from home mutually accepted by them. So these 4 points are very important. No change, nothing. Okay. Yes, sir. Now, notice of claim for maternity benefit and payment thereof. Now, she should make an application in writing. She can make an application in writing, or nominee can also make an application. So when should I pay? The payment goes like this. If he's taking a prior thing, prior amount can be given as advance. For the post kind of thing, once you produce your result of your delivery, from there 48 hours is a time for which the employer should make a final payment. So prior period can be taken in advance, post can be taken later. Now, usually if the employer is providing some hospital facility, don't worry. If not, you are entitled for extra called as medical bonus. You are entitled for something as medical bonus at 3,500 rupees. Now, there is a leave for miscarriage also. 2 weeks for 2 weeks. Tubectomy. Additional leave of 1 month can be also availed. After this thing, after your childbirth, you are entitled to, along with the following rest intervals, you are entitled for a crutch facility as well as nursing break. Nursing break is allowed like 2 breaks till the child reaches 15 months. There is something called as a crutch facility, and that crutch facility is like when there are 50 or more employees, employer should provide a crutch facility like a child welfare facility, and you are allowed to go there 4 times in a day other than your normal hours. So for
including other than the nursing time, but including the normal intervals. Normal intervals as an employee.
Okay. No.
So including rest intervals.
No.
Including normal intervals.
You
will have it as an employee.
4 times including normal intervals.
Nursing.
You have access to crutch facilities during your interval as well as 4 breaks.
No, they gave including only.
But you make sense. That's how it's.
Crutch facilities allowed.
It's not interval.
Say crutch facility. So people, I'm allowed to go to visit my child only for 4 times. Rest intervals I can go and visit along with that 4 intervals. So people read from a crutch facility angle. You can access the crutch facility 4 times including the interval. It's not like 4 times between your intervals. You are allowing extra 4 breaks including your intervals. Whenever you want to go see the baby when you are having an hour of rest. Along with that 4 times you are allowed.
Provided that an employer shall allow 4 visits a day to the crutch by a woman, which shall also include the intervals of rest allowed to her.
Which shall also include. Which shall also include this extra. No?
Okay, then how do you say something which is inclusive? Inclusive, I can't say the 4 times includes this. How do you represent?
Within the total working hours, total rest period. It's allowed for 4.
Including the rest intervals, taking the rest or reminding the intervals.
Rest. In your rest intervals also you are free to go to visit your baby. Other than that, you will allow 4 times to go visit your baby. Done? Okay. So. Okay. Yes. Done. Now people, employee compensation. Your important topic, a new topic is employee compensation. So people, you have to report fatal accidents or serious bodily injuries within 7 days to the authorities. So you have to report the bodily injuries or fatal accident within 7 days. Bodily injury includes permanent loss or injury to a limb, permanent loss of sight, hearing, etc., fracture of limb, etc. Now, employer to make a compensation. If the employee suffers a personal injury by accident or occupational disease given in Schedule 3, Schedule 3. You have to mug up the name. Schedule 3. The employer is liable to pay compensation except when disablement is less than 3 months or injury caused due to his influence of drinks, willful disobedience of safety, etc. Okay. Now, people, for a plantation worker, if I have given a shelter room, and the plantation worker was working under me for more than 60 days, because of a failure, shelter room failure, some accident happened to that particular plantation worker, you might have to give a compensation. Compensation payable to plantation worker, extra point.
Except when it is by the, because due to the
Fault of the occupier, occupant.
or natural.
Okay. Now, people, amount of compensation, very important question. Sir, amount of compensation. Amount of compensation based on relevant factor. What is relevant factor? Relevant factor is something which is decided as per your this code schedule. Schedule 6 talks about organization. Schedule 6 talks about something called as a wage factor, a relevant factor. Based on the age, you will have some standard. Say for example, you are 85, you are 43 years old. You will have some relevant factor. So assume that there is a death happened in the organization. Because of that, I am going to pay a compensation. How much I should pay? 50% of your monthly wages. What is wages? The
Basic pay,
basic pay, DA, for the purpose of Equal Remuneration Act under different code, previous code, you will have conveyance allowance, settlement award should be added back. If your excluded components are more than 50%, should be added back. If the remuneration paid in kind, 15% should be called as wages. Super. Now, in case of permanent disablement, you will pay 60% of the monthly wages into relevant fact. So, death is 50% of wages into relevant fact. Permanent total disability is 60% of the monthly wages into relevant fact. These both are subject to the higher amount as per prescribed by the government. Now, for a permanent partial disablement, you have to check one more schedule called as Schedule 4. Correct? Schedule 4. It's like you compute as per permanent total disablement, and in the Schedule 4 they will talk about how much percent I should give. So, based on loss of earning capacity, I will say this is the compensation but pay only 80%. So, pay accordingly. Okay. Fourth point. In case of temporary disablement, you should pay 25% of your wages on every 15 days. Now, I hope it's clear. Now, people, review. You are giving a half month. So, at temporary disablement, you will give a half monthly payment. Sir, what if he is temporary disabled and he is enjoying that? He is not coming to office every time enjoying chuma. Law said it is mandated to do a review. Review can be initiated by the employer as well as employee. Employer feels that my pain is more, now I need more compensation. Then also he can initiate. Or employer feels that now it's time to stop the temporary disablement facility, he can do a review. When I am doing a review, the outcome can be I'll continue the payment, or reduce the payment, or increase the payment, or finish the payment. At times, if the half month payments are exceeding 6 months, I feel that it's not necessary to pay a half month payment, rather I can pay a lump sum payment. I can compute that into a lump sum payment and pay. It's completely fine for the employer to pay a lump sum payment. Now, how will I distribute compensation? Directly pay to the employee. If they directly pay to the employee, if the amount is up to 15,000. You have to hand it to the compensation authority if the amount is more than 15,000.
5,000. 5,000.
5.
5,000.
Other
Okay.
deposits, maybe it's,
Okay. Sorry. If the amount is up to 5,000, you can directly pay. If the amount is more than 5,000, you have to through a competent. Okay. 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 4,999 you can directly give. 5,000 or more should be given to the competent, they will give. Now, in case of any amount, lump sum amount, payable to a woman or a legally disabled person, you have to give to competent authority only. You cannot directly pay. So 2 points are slightly important. Hey, let's directly employee കൊടുക്ക முடியும். Oh. Okay. People, you have to give a notice within 2 years of the incident or death, as the case may be. People, same time limit 2 years will be applicable for 1 year only in case of employee working outside India. Working outside India in a vessel, ship, etc. Instead of 2 years, you have to maintain commerce. We are talking about 1 year. 1 year is the time framework. Ship or aircraft is lost. We presume that 18 months is the time framework to pay compensation. So people, registration of agreements. People, whenever there is a lump sum amount which you have decided based on a settlement, the particular amount or half monthly payment, all amount is payable to a woman or a person under legal disablement should be registered. The agreement should be registered whenever you are paying a lump sum amount or monthly payment, half monthly payment or half monthly payment converted to a lump sum payment or payable to a women or legal disabled person. You have to make sure that is in writing agreement. You are enter into an agreement. Register that. Now, people, last part of first code is regarding what are the social security for unorganized sector. Unorganized sector. So, how will I pay compensation for an unorganized sector? People, for unorganized sector, gig workers, plantation workers, etc. We don't. Platform workers, etc. We don't have a employer-employee relation. So, law is telling you, let the government take an initiative. For understand, for a gig worker or a platform worker, there is something called as aggregators point also coming into picture. Aggregator point also. Now, generally, you have unorganized sector to have some policies. So, central government or state government can have some policies for the unorganized sector. Like for your there's a street vendor, you have a policy. The policy can cover all these concepts. Life and disability cover, health and maternity benefits, old age protection, education, any other benefits. You can have policies regarding that. That's central government policies. State government policies can include PF, employment injury, housing, skill upgradation, funeral assistance, etc. Usually funding will happen from central government and state governments, central government, state government contribution from workers as well as CSR fund. CSR fund. Now, people, self-employed workers or unorganized sector, how will I know that what are the schemes available, what are the benefits available? There is something called as helpline and facilitation centers. People, helpline and facilitation centers which will help you with the registration under the scheme, and they have helpline numbers where you can ask your doubts. They give you a clarity on how to approach that thing. Now, people, one point which is very important for a gig worker, platform worker. Again, unorganized sector will have a general point as well as gig and platform worker. So, gig and platform worker will have life and disability cover, accident insurance, health and maternity benefit, old age protection, creche facilities, etc. Now, this scheme will have central government, state government, workers' contribution, CSR plus aggregators. Who are aggregators? People who are connecting hotels with the customer, intermediary. So aggregator, they can ask you, who are the aggregator? You have to know who are the aggregators. Ride sharing facilities, food and grocery, delivery services, logistics services, e-marketplaces, professional services, healthcare, etc. These people are called aggregators. Aggregators should contribute minimum 1% of their turnover or maximum of 2% of their turnover. But they need not pay more than 5% of what they pay as employee cost. Their workers. So keep this in mind. Aggregators, this part can be a question. Gig workers, aggregators. This point. So aggregators should also contribute to the schemes which is set up by the government. That's how this code. So this code talks about EPF and contribution, ESA and the benefits, gratuity general provisions. Maternity will have sub points regarding prohibition ban and payment ban. Then compensation regarding serious issues. Then last point regarding unorganized sector. Easy, but make sure it's done properly. Your ESA part as well as your compensation part is slightly lengthy. So make sure you plan accordingly. Some bullet points. Remaining full swing. ESIC konjam liberal. Make sure you are planning it in a proper way. Okay, 2 minutes rest. 2 minutes rest. Breathe. Marbudiyum kolda.
Yes, yeah. I mean, good on remaining numbers are ready to Instagram.
Okay, people. 182. People, page number 182. People. Code on wages, page number 182. Okay. People, first part of this code. So code on wages is regarding how to make wages, how to make timely payment of wages, what are the deductions allowed, what about the bonus payments, what about equality of payment. So these are the points which this code on wages will cover. So people, concentrate. First point, code on wages talks about Equal Remuneration Act. Equal remuneration related point. Point A. They said, employer shall not do a prohibition based on gender with respect to payment of a employee, male or female, if the workers same nature, same work or work of similar nature.
Similar nature, responsibility, experience.
Same work or work of similar nature. And for the purpose of this thing, for the purpose of making it uniform, employer shall not deduct the salary, deduct the payment. Third point, at the time of recruitment, you cannot have a discrimination. So employer shall not make a discrimination with respect to payment, with respect to recruitment, or for the purpose of this thing, you cannot reduce the payment. First point. That's part regarding Equal Remuneration Act. Now, regarding minimum wages. People, appropriate government can fix minimum wages. Minimum this much amount should be paid, so that exploitation is avoided. Minimum wages can be fixed by appropriate government. Appropriate government can be central government or state government. Appropriate government will fix the minimum wages. Where employees are employed on a piece rate, also to ensure that they are safe, you give a time rate payment. So, the criteria by which the government will fix this particular minimum wages based on skill of the worker as well as the arduous nature of the work. How much strain he has to take to work in that environment. Now, people, How will I compute minimum wage? Anyway, there's an element called as floor wage. You have to keep that in mind. But minimum wage can be computed based on three parameters. One, basic pay plus your cost of living index, or basic pay plus your cash value of concessions. Third, including everything. These are the three ways in which you can compute the wages. Okay. Sir, how do I fix the minimum wage? Minimum wage can be fixed by two methods. One, a committee method or a notification method. Central or appropriate government can have subcommittees. Those subcommittees will work on a plan. Based on that plan, they will come with a minimum wage. Or they will give a notification in the official gazette, ask people to comment. Based on the comments, they will come with the thing. Once this is done, when we have to publish that, we will give it for public comments. Ask people to comment on your price. Comment on your wage. Wage can be revised. You have to review or revise within a period of 5 years. Now, sir, you have a freedom to fix minimum wage, but minimum wage is fixed by appropriate government. Appropriate government can be central or state government. But for a particular India, central government can fix something called as floor wage. So floor wage is something which serves as a baseline. So floor wage is a basic floor price which is decided for wage which is decided by the government. Central government. So it's given by central government or appropriate government. Now it is based on minimum living standards. Based on living standards they will fix. Central government is also vested with the power to fix different floor wage for different regions. They are allowed to give that. Now, minimum rate of wages fixed under the law cannot be less than the floor price. And for this purpose, you cannot reduce that thing. Make sure floor wage is there. Your minimum wage should be more than your floor wage. That should be the duty. Now, if the employer is working less than the requisite hours also, not because of employee's fault, because of employer's fault, then he is required to get paid for the whole day. Okay. Now, appropriate government is allowed to regulate the time of work and hour which is constituting a normal day and fixing the overtime payment. But that is not in case of workers who are working on an emergency basis, preparatory or complementary, washing facility, lubricating the machine, those kind of people we don't have this thing. Technical reasons cannot be completed before the duty is over, or irregular people who are working in irregular natural forces. Those people we don't have a stricter time for working hours. Otherwise, everywhere appropriate government can fix what is the working hours. 8 to 10, 5 to 3. These areas you cannot fix. Now, third point is regarding payment of wages. So, minimum wage is done, payment of wages. Payment should be made in coin, currency note, check or crediting. Page period can be anything, but it can never be more than 1 month.
1 month.
Time frame. If I am a daily wage worker, you will be paid within end of the shift. Weekly basis by the end of the week.
Weekly audit.
Fortnightly, 2 days from the end of the fortnight. Monthly basis, 7 days from the end, 6 month, 7 days. Removal or termination should be paid within 2 working days. Now, next 2 points, very important, deductions from the wages and fines. Sir, from the wage, what are the amounts which I can deduct? First rule is simple, no deductions can be more than 50%. Total wage period, 50%, more than 50% is not allowed as a deduction. So what are the things I can deduct? Fines, absent from duty, damage or loss of goods, house accommodation, amenities and service, recovery of taxes, overpaid payment, housing, loan interest, income tax statutory pay, TDS paid, social PF contribution, corporate society payments, anything which is related to your employment and employer has to pay, I am paying, that can be deducted from the salary, wages, and the wages, this deduction cannot, per month cannot, per wage period cannot be more than 50%. Sir, can you explain me on fines? Yes, fine is a separate topic. Fine. So regarding fine, one of the deduction allowed from your wages is fine. What are specific provision with respect to fine? You have to get a mandate approved from appropriate authority regarding the fine. The fine amount cannot be more than 3% of the total wage period. Below 15 years age, you cannot claim wages from them. Notice should be displayed in the proper place. Then, income made in installments or after expiry of 90 days. You have to maintain a register for the particular wages. It is imposed from the day in which the event has already occurred.
After 3 months, by the time you can.
After 90 days, I cannot
90 days are recovered.
I got any fine after
90 days. அது சொல்லியாச்சு அது 90 days. அப்புறம் maximum 50% தாண்டக்கூடாது டிடக்ஷன். மொத்தம் 50% தாண்டக்கூடாது டிடக்ஷன்.
Now people, third code, most important point is regarding bonus. Bonus. People, when should I pay bonus? When should I pay bonus? 8 months from the end of the accounting year. 8 months from the end of the accounting year. If there is a dispute regarding that also, pay minimum, then after the dispute settled, 1 month of the date of dispute, I should pay. So when will I get a bonus? If I work for 30 days in the accounting year.
Yes.
not drawing salary.
So law is telling you, you are entitled to a bonus provided you have worked for minimum 30 days in your accounting year and not more than the salary prescribed. So that salary per month, you cannot be enjoying more than that salary. So up to this salary and 30 days of working will enable you to collect bonus. So how much is minimum bonus? Minimum bonus is 8.33% of the wages or rupees 100, whichever is higher, whether or not the employer is having allocable surplus. Profit illa allocable surplus. So now for the timing we are taking it as whether or not the employer is having profits. But we use the word allocable surplus. Sir,
What if
if
I have a
I have a higher allocable surplus, so people
higher wage?
understand, I have to pay wages. From the wages I have to pay something called as bonus. So bonus is how much, sir? 8.33%. Minimum. Now people, we are not talking about something called as if the company is having profits or not. We talk about something called as allocable surplus. Sir, if the allocable surplus, say assume that allocable surplus is that amount which is attributable to that person. So assume that your wages into 8.33 comes to 800 rupees. Wages into 20% comes to 2000 rupees. Assume. So maximum bonus is 20%, minimum is 8.33. Now let's decode. Sir, allocable surplus, I am in a position to pay him 8.33. Then pay 800 rupees. So I am in a position not to pay anything because I don't have a profits, I don't have an allocable surplus. Still you pay 800. Sir, company is lost only, sir. Still pay 800. So I am good enough to pay 12% of amount. Pay 12%.
Proportionate.
I mean good enough to pay 12%. Pay 12%. Meaning that much amount, higher amount. So I am good enough to pay 16%. Pay that higher amount. So I am good enough to pay 20%. Pay that amount. So I am good enough to pay 25%.
No, stick with 20,000.
Maximum 20 is only you have to pay. Whether or not you are having allocable surplus, you have to pay. You are having more allocable surplus, you have to pay proportionality. More allocable surplus also, make sure you pay maximum of 20% only. Okay. Now, employer can plan something called as productivity linked bonus, subject to minimum, subject to maximum. Minimum, maximum is there, but based on productivity, he can add. Okay, you produce more products, I'll give you more bonus. Can be your part.
Based
No.
on agreement.
Employer and employee. Now, people, Say for example, for a newly incorporated companies and all, first 5 years, you need no, I mean,
Only profits are
okay,
there.
okay, okay, so I have to do a set of set-ons, then I'll come back.
36 you have to do. Section
Second
36.
set of 30.
Okay, let's see. People, from the bonus, I can do a proportionate reduction, provided you are not working. You are not work, I can do a proportionate reduction, allowed. But does it mean that laid off period, temporary disability, maternity benefit are called as not working? That is working days only. Other than those things, you have taken leave. That leave can be deducted from that all. So number of working days minus those days you have taken as leave. Based on that way, you will give you proportionate amount of bonus. But if you are disqualified, dismissed from your office because of fraud, riotous behavior, destruction of property, sexual harassment, etc., employer is free to not to give you bonus. Now, sir, what if I have multiple branches? You are having separate book accounting treatment. Treat separately. If not, it's okay. Now, people, we have to give bonus whether or not we have allocable surplus. So, what is allocable surplus? So, allocable surplus is nothing but available surplus
Percentage of our
into some percentage. So, again, we are not talking about gross profit. We are talking about available surplus into, so available surplus into 60% in case of banking company or 67% of normal company is called as allocable surplus. So based on allocable surplus, you will give bonus. Whether or not company has made profit illa allocable surplus. What is allocable surplus? 60 or 67% of available surplus. So what is available surplus?
Gross minus deduction under 30.
It's gross profit minus deductions.
Deductions.
What are the deductions?
Depreciation, direct tax and the bonus. Other principle.
Depreciation and direct tax. But you have to add back
Bonus of the
Previous
previous year.
previous year's profit. I mean previous year's
Difference.
profits minus bonus.
Before tax.
Previous year's profits only.
Ah.
And compute the tax element. Tax benefit which you have received. Previous year profit minus bonus or previous year profits only. Think about the tax benefits. So assume that previous year profit minus bonus, and when you compute tax, you pay tax of 25 rupees. Only on computation of profits you paid bonus of tax of 40. So because of that thing, you claimed an exemption. That exemption should be added back. A benefit which you have received out of deductions from a bonus and tax payment in the preceding year should also be added back.
Yes.
So how will you compute? Again, the computation part goes like this. Sir, I have to pay bonus based on allocable surplus. What is allocable surplus? It is 67% or 60% of available surplus. What is available surplus? Your current year gross profit minus
PT
direct tax depreciation. Direct tax include agricultural tax.
plus
Then you have to add back
the difference
the difference between the percentage of benefit which you have received, because previous year you have deducted bonus, hence your tax portion is reduced.
Use and the benefit you add back to the
The benefit should be added back. That amount is called as available surplus. Available surplus into 67 or 60% is called as allocable surplus. Based on that, you will say bonus.
Yes.
Now, sir, this year I am having allocable surplus good enough to pay 6% only. How much I have to pay? 8.33. I have allocable surplus to pay 6 only. Still I have to pay 8.33. This deficiency. So I have to take a loan and take pay. The deficiency of 1 point something can be carried forward up to a maximum of 4 accounting years. Sir, this year my eligibility is I have more profits. Say for 20% I am able to pay. So I am able to pay 28%. I should pay only 20. That 8% can be carried forward up to 4 years. This is called set off or set on provisions of bonus. Yes, people? Set on and set off provisions of bonus. Now, so people, the rule goes like this. Even though we have set on set off provision, whenever the company is incorporating, initial 5 years, only if you have a profit, only you have to do bonus. 60 years, 7 year onwards. So 50 years, first 5 years, there is nothing called set on provisions also. From 6th year onwards, you can do a set on provisions from 5th year. Meaning 7th year, I am having deficiency, I can carry forward from 5th and 6th years. 4th year profits you cannot carry forward because set on provision will start only from 5th year onwards.
So, போன வருஷம் நான் எவ்வளவு போனஸ் கொடுத்தேன். இன்வேஸ் அந்த போனஸ் எனக்கு அகைன் எனக்கு ஆட் பேக் பண்ணிடுவாங்க.
போனஸ் டாக்ஸ் பாயிண்ட் தானே.
டாக்ஸ் பர்பஸ்க்காக போனஸ் வந்து 37 செக்ஷன் 37ல எக்ஸ்பென்ஸ் காட்டி நான் ரெடியூஸ் பண்ணிப்பேனா 717 அந்த எக்ஸாக்ட் போனஸ் அமௌண்ட் ஐ வில் ஆட் பேக். அது கரெக்ட் தான். கரெக்ட் தான். திஸ்
People set on set off 4 years. So people who are watching the marathon, if you find that bonus is challenging, make sure you watch some YouTube video or my previous video on bonus act. You'll get a grip. It's completely fine because with no new code, points are less. But the basics are old only. You can always refer that. Now, say for example, bonus I have to pay within 8 months. What if I have already paid a Pongal bonus? You can adjust that from the normal bonus. Statutory bonus can be. Customer bonus should be adjusted with the statutory bonus. Time limit 8 months. In case of dispute, 1 month from the date of dispute. Now people, bonus is not applicable for the following establishment. People, what are the establishments which is coming under the out of the purview of Bonus Act? LAC, your RBI, universities, shipper. So these are out. Indian Red Cross Society, etc. are out of the purview of your Bonus Act. But public sector undertaking also out of the syllabus, out of the picture. But I am a public sector undertaking. I am in competition with the private segment, and 20% of the revenue is coming from that, like oil, gas, like your Indian Oil Corporation is in the competition with Reliance, and Indian Oil Corporation is getting 20% of revenue from petroleum. Petroleum is a product where they are competition. That industry should also do bonus. A public sector which is in fight with a private segment will also do a bonus. Usually public sector undertaking need not go with bonus because they will have different policies of government. You have to revisit the recording, da. So current year and previous year accounting year. So current year we have to pay bonus based on allocable surplus. How will you cover the allocable surplus? Available surplus is 67%. What is available surplus? That's how we are computing. take your gross profit for current year minus depreciation minus direct tax paid. You will come with an amount called X. Then previous year you have done bonus also, no? Assume the previous year gross profit was Y. Then you give bonus. Assume the amount is B. And you pay tax. You pay tax of T1. Just see, if I have not given a bonus, I have to pay tax of T2. Last year, last year's profit minus bonus, then you give a tax element is this much. Without tax element, this bonus is, without bonus element, tax is this much. Compare this. Say for example, you saved T2 minus T1 with respect to bonus savings. That extra benefit of tax percentage should all be added back. X plus this benefit is called available surplus. Done? Okay. Maybe one more point to finish this thing. Inspector cum facilitators. You already know because you have already seen that topic. Inspector cum facilitators. Other parts are similar to your previous topic, death, disability and all. Now I want you to tell me the duties of an inspector cum facilitator. Inspector cum facilitator will come under this chapter and some other code. Which code?
This is the occupational.
Occupational safety. What are the duties of inspector cum facilitators?
Inspect, investigate.
You can inspect, you can do inquiry, you can take samples of article, you can take the books, so you can take a mark of the books.
Master roles.
Yes. So people keep that in mind. They can ask you a question on what are the duties of inspector cum facilitator. Inspector cum facilitator. So you should be knowing because we have 2 chapters which talks about inspector and facilitator. Previous call was regarding inspector, now we call it the inspector cum facilitator. Whenever there's an accident happen, he can inspect, take samples, he can ask for investigation. If the employer is not allowing, go inside with the police support. All those are rights of this particular inspector. You have to read that properly. Okay, done. So we're done with 2 codes. We'll take a break, we'll come back with the other 2 codes. People bonus very important, make sure you're doing it properly. Okay then. Under control. We'll part 3, which is code on occupational safety, health and working conditions. Occupational safety, health and working conditions. People first definition. So understand, here we are going to talk about how the factory is so good, how the particular employer can employ people in that factory or establishment. Sir, how will we know that whether the person, say for example, we are doing a hazardous nature work, a mine. So how do we ensure that the people who are employed in there are having the physical fitness? So law said, okay, to work with a factory or occupation, such kind of thing, we'll have a competent, you will have a chief inspector cum facilitator to check whether people are good enough. So chief inspector cum facilitator cannot run across the different parts of the country. So he will appoint some authorities or some people. So Chief Inspector come authority, Chief Inspector come facilitator will appoint individuals or some laboratories for the purpose of conducting the physical fitness, mental fitness of a candidate. So that teams are called competent person. So competent person means a person or institution recognized by Chief Inspector cum facilitator for the purpose of test, examination, inspection before a person has been entering into the organization or before the establishment has been set up. So Chief Inspector cum facilitator will talk about how much qualification an individual should be having to conduct the test paper, or how much quality the laboratory is having to conduct the investigation. So they can talk about qualification experience of the individuals connected to that particular laboratory, or those inspectors who can go, those medical supervisors who can do the inspection. That the education qualification of the inspectors, the medical officers can be decided by their chief inspector. Those people are called competent enough to do the investigation. Now, okay, this chapter applies to all those establishments. Establishment means an industry, trade, business, etc. wherein 10 or more people were employed during the preceding year. So 10 or more people are employed in the organization last year. Any day in the last 12 months, we call that it is a establishment. Establishment. Now, people hazardous process. Hazardous process means a process given in first schedule unless you give special care. The raw material, finished goods, semi-finished goods or waste or anything which may result in two things. One, material impairment of health of people or pollution of the general environment. These things can be the outcome of hazardous process. Hazardous process. People, industry. One important definition, industry means wherever a systematic activity is carried on directly or through an agency for the production or distribution of goods or service, whether or not capital is invested, whether or not profit is included, but does not include charitable or philanthropic service, sovereign functions of government. Third is domestic service. Domestic service. So, wages,
Includes PPDA.
basic pay, DNS allowance, retaining allowance. Remaining everything are excluded. But if the excluded portions are more than 50%, that extras can be added back, should be added back. Then kind means 15%. For an Equal Remuneration Act, we will have to add 4 more points. Now, okay, first question. What are the duties of the employer? Every employer shall
Hazardous.
ensure that the workplace is free from hazards and likely to cause injury or occupational disease. Second, comply with occupational safety and health standards. Provide such annual health examination free of cost. Ensure that disposal of hazardous waste is done properly. Issue of letter of appointment has been made mandatory. The previous law is not mandating that. Now, immediately after the commencement of this code, you have to give a appointment letter within 3 months. Now, employer will have to report accidents or bodily injury. Accidents, yes. Accident due to death, okay. Bodily injury causing that person taking off more than 48 hours should be reported. If the report is given, the authority should also do an investigation. Chief Inspector should do an investigation. Okay. What are the duties of employees in a workplace? Take reasonable care of their own health and safety. Comply with health and safety requirements. cooperate with employer in fulfilling statutory obligation, report any unsafe or unhygiene situations, not willfully interfere with misuse or neglect of appliance. Now, employee a right and duty to talk about imminent danger. Important question. You will have a right to get information regarding the health and safety in your establishment. Similarly, whenever there is a imminent danger occurrence, you have to report to, whenever the establishment is having a safety committee, go with them. If not, employer directly, if not, inspector come facilitator. If the employer also feels that there is a problem, he'll take a remedial action. If not, also we'll have to report to the inspector, competent authority, who will take the necessary action. So you have to report your imminent danger to the safety committee, employer, or even to the inspector come facilitator. Duty of an employee. Now, we saw a general question regarding OSH standards, occupational safety standards. Central government may notify OSH standards. First point, the standard or scope will have hazard control, physical, chemical, biological or other hazards. There should be a norm for hazard management. So, central government should standard OSH standard. Scope of standard should have hazard control, hazard management. Medical examination of post employment. After employment also medical examination should be there. Report by designated authorities. It can be specific sector specific measures also. These are with respect to OSH standards. They can ask you a question on how important is OSH standard for occupational safety. So just brief that OSH standards are done by central government. For that you have a scope. Management of hazards are very important. You will have designated bodies to give a report. Medical examination should be done even post employment. Sector specific standards also can be set by the authorities. Now, people, employment safety kaga we have safety committees as well as safety officers. Safety committee is okay, you should have representation from both employer and employee. But for a safety officers are mandatory for a factory with 500 or more work. Factories having hazardous process 250 or more. Building or construction worker with 250 or more workers. Mines with 100. So these establishments should have safety officers, mandatory safety officer appointment. Okay, safety committee and safety officers. Now, people, duties of employer with respect to health, safety and welfare. CDVD holders, and that housewife cleaning, washing, etc. Now, people, how do an employer establish that health, safety and working conditions are established? CDVD holders. Okay, CDVD holders. C for cleanliness. D for disposal of waste. V for ventilation. D for
Free from dust.
taking dust. H for artificial humidification. O for overcrowding. L for lightning. D for drinking water. U for urinals. S for separate urinals. Spittoons illa. Okay. CDVD holders. So CDVD holders. Cleaning, dust. V, ventilation, again dust. So remember CDVD. Hold, HOLD. Artificial humidification, overcrowding, lightening, sufficient lightening, drinking water. Hold. urinals should be made separate and hygiene urinals, holders, CD, BD holders. Online, CD, BD holders. Now, there are some welfare provisions also. We thought about a story wherein a housewife is washing. So washing facilities. After washing, she'll dry the clothes. Oh, she'll take a bath and dry the clothes. Okay. Then she'll sit for a canteen. Sitting. Second is sitting rooms. Sitting rooms. Place for keeping clothes is sitting. Sitting, then she'll sit. Eating. Canteen. Canteen that time eating now, she'll know that, you'll realize that there is a wound. So she'll do a first aid. First aid should be there. Then other than this thing, ambulance, medical facilities, halting room, separate shelter rooms, welfare offices, temporary living accommodation for building workers free of cost. People, so CDVD holders, then welfare you should have a separate sitting facilities, separate washing facilities, separate bathing facilities, separate shelter rooms, first aid kits, ambulance, welfare officers. These are part of employer's duty to provide welfare, health and safety of an employee. Online, okay ada? Now, 50 or more workers, creche facilities till the child reaches 6 years of age. People, working hours. Remember the point, extra scenarios or general worker, mine, motor workers and working journalists. First, general worker, maximum 8 hours, intervals and breaks to be notified. Mine, works arranged in such a manner, including the shift under the mine or outside, should be within the magical limit. Now, motor vehicles. Total time spent in the motor vehicles include running time of the, I'm a bus conductor, running time of the bus, other loading unloading work, as well as terminal attendance. Attendance at the transport station should also be counted as my working hours. For a working journalist, they have a maximum working of 144 hours in a 4 weeks time. Every 7 days you should be given 24 hours of rest. So 144 hours total in 4 months period, 4 weeks period. Minimum 24 hours of consecutive hours of rest in every 7 days. Now, sales promotion employee and working journalists, they will be given 1/11 of totally paid for every. So, earned leave of 1 for every 11 days. Similarly, medical leave of 1/18 into half. Half wages for 1/18. So 11 days can give one day's payment leave. For a 18 you will get half days paid pay. Now, okay. Weekly holiday rule. No worker shall be required or allowed to work in an establishment for more than 6 days in 1 week. So, more than 6 days in any 1 week is not allowed. Motor vehicles department is giving a special condition, not more than 10 days consecutive to work unless you get a. Now, can you work overtime? With the approval of employee, you can work. Employer should go ahead with the overtime, but overtime is twice the payment. Okay. Night shift, there is a point where they say when a shift extends beyond midnight, a day off will commence from after 8, not from the midnight, from the time at which your shift completes. Then shift completes. 1 day of rest will start from shift completes. Then the following day. So since I have worked in the Monday morning for 3 hours also, which is part of. So it's actually Tuesday morning. Monday extended till Tuesday 3 hours in the morning, we have to think about as if it's a Monday's working hours only. 2 examples, make sure it's done properly, understand examples. Then, now, no double employment in factory and mine. Prohibition of overlapping shift 225.
How many hours gap? 3 hours or 1 hour?
Enna gap?
The one shift to another shift for a gap.
Yeah, one full 24 hours plus.
Oh yeah, clap. Overlap the overlap. Exactly.
Okay, see. Hello notice board. People, Bhagya, listen. Change in work system. Any proposed change in system of work that requires altering the notice shall be intimated to the inspector or facilitator. Not made until 1 week has elapsed since the last stage. Before you go with the next change, previous change should be 1 week.
This only
Discussion.
Discussion. 1 week. Months கணக்கு தான் பேசணும். அத 3 months அத once நீ பாலிசி மேக் பண்ணனா 3 months க்கு ஒரு நெக்ஸ்ட் அப்புறம் மாத்தணும்.
So people, annual leave with wages. They can ask you a question, annual leave wages. Every worker who has worked for more than 180 days can get 1 day leave, earned leave for
180 or more.
180 or
work for 180.
More than
1 day more than 180.
Work for 180 days, you can get 1 day leave for every 20 days of work. Adolescent work 1 out of 15.
50.
Mine also 1 out of 15. But for the computation purpose, maternity annually everything is counted, but they will not be given. That's not added for the leave. For the purpose of eligibility, they are adding, but for the leave, those leaves will not be added back. Take a screenshot and make sure it's done properly. Marathon. So unused leave can be carry forward, but maximum carry forward allowed is 30 days. But you can encash that also. Inspector come facilitator, you already know. Duties very important. Powers of inspector come facilitator. Already known this point. You have to be very strong with this point. Okay. Special provision for contractors. Where is the provision? Whenever an establishment is having 50 or more people coming under contract worker or a contractor employing 50 or more workers. Establishment which is having 50 or more contract workers or a contractor employing 50 or more workers.
Manpower supply.
Okay. Licensing of contractor. So contract, they can ask you a separate topic. Licensing of contractor. Yes, you have to do a contractor should get a license. Okay. Then license is usually valid for 5 years. If you are not having a qualification or you are not even in a position to put the security deposit, you can always avail a work specific license. For a license condition is they'll ask you to explain on hours of work, fixation of wages or essential amenities for the contract labor. Okay, people, again important question. Usually we are trying not to have a contract worker for a core establishment. What is core establishment? Main purpose of the thing, which is not washing facility and all. Go back your definition part where we discuss about core part of a work. Now, when there is a permanent job available, don't hire a contract labor. Except the following scenarios. 1. Normally functions of an establishment that activities usually done through a contract labor. Activities does not require a full-time labor or sudden increase in the core activity. These are the grounds in which you can hire contract labor. Otherwise you
For the core activity.
for the core activity. Otherwise you can't have contract labors for the core activity. Allied activities you can have contract labors. Okay. How will you approve and license a factory? You submit a plan, prior permissions, you'll get a licensing. 30 days later, if you are not getting something, it's a deemed approval. Appeal provisions are there. Factory. What is factory da?
20 with power.
Like 10 or more power.
Factory codes in the codes.
In the chapter.
20 or more with power, 40 or more without power.
Because here it's 20 or more, because we are talking about occupation safety health. Occupational safety chapter will talk about 2040. So, people, there is one property where are multiple organizations working. It's a joint liability of the owner of the premises as well as different establishment working under them. Okay, people, another important question is regarding how to disclose hazardous process. Disclosure of hazardous process. People, every factory involving a hazardous process which will cause a material impairment to the health general, these people should disclose the information to the occupier should disclose regarding all dangers, all health hazards connected with the particular activity, hazardous process. Second point, it should be informed to the employer, workers under them, chief inspector as well as the local authorities. Every occupier should have a health and safety policy. Every occupier should have a health and safety policy. Then, accurate waste information, how you are going to dispose your waste should also be part of your information given. On-site emergency plan and disaster plan. On-site emergency and disaster control should be informed to the public as well as, workers as well as public in the local thing. Okay. Before starting this hazardous process, make sure you give information to the competent authorities. That is for further comments. Last line here, Social Security Fund. Appropriate government has established a Social Security Fund also to protect the unorganized sector. This also can be one amount for the unorganized segment. So people, this chapter is comparatively easy but more of general points. Occupational safety is actually easy topic, but make sure you have a lot of general points that everything is hazardous. So if you don't remember anything, also write hazardous process. Write hazardous process 2 times. Easy to score. Avaloda, you write Avaloda, no? Avaloda. Different places you write Avaloda, that's all. So hazardous process, you can write Avaloda. Okay. So people, last code is on industrial relation. Industrial relation code is something which is here to, we know that whenever the employee is not happy, he'll go with a strike. Employer is not okay, he'll go with a layoff. Layoff.
Correct.
Lockout. So people, I can go with a lockout, employer, layoff, strike from an employee angle. So for those things, before we reach that stage, let's do a amicable settlement. That's why we have conciliation officers. We'll have an arbitration process. So industrial relation is to ensure there is a harmony being established in an organization. Industrial establishment should maintain a harmony. For these things, you should be knowing some important terminologies. People, terminologies are very important. Layoff. What is layoff?
Employer doesn't have the...
Employer is because lack of energy, lack of raw material, power is not there. These reasons temporarily, it's not like a harsh reaction by an employer because of his helplessness. He's doing something. That kind of temporary sending out of people are called layoff. Layoff. You should know the definition. Know the concept given in the definition. Lockout is more complex. I close because of my refusal to give you job. Employer is because of a fight. Employer is locking the premises called lockout. Retrenchment. An employer is terminating the job of an employee other than way of punishment, other than way of voluntary retirement, other than superannuation. Some reasons A taking your place, we are sending them out. We call it as retrenchment. So a layoff going beyond a prescribed time limit is called as a retrenchment. Strike. And employee when he is not happy, he can always argue a fight called as strike. People, for a amicable settlement of our, so first part is regarding settlement of disputes. Whenever there are problems in your organization, you will have works committee one thing, grievance redressal committee, and or even trade unions. You have a works committee where 100 or more workers are working. You will have a grievance redressal committee where 20 or more workers are working. So, grievance redressal committee is also for a problem solving. Works committee is also there. So, primary level is your grievance redressal where you have 20 or more workers are employed. 100 or more workers are established, you should have a works committee. Now, that's basics. Our first authority is trade union. People, trade union shall be registered. So they can ask you on registration of trade union. No trade union shall be registered unless 10% or 100 workers, whichever is less, are part of that trade union. And application should be made by 7 people. So 7 people may make an application, but provided 10% of the total strength of workers are part of your supporting your union. Now, a registered trade union shall always at times have 10% of the total crowd supporting them, and minimum 7 should be always with them. So 7 members should be with the trade union and 10% of the workers should also be supporting the trade union. The trade union bylaws, rules, we'll talk about name of trade union, purpose of general funds, because we know special purpose is political only. General funds, what are the purpose which you can use? List of members of trade union and other factors like AGM, annual audit, etc. when you register the trade union, you should give a declaration, affidavit, saying that I'm complying with the copy of the, I'm giving the copy of trade union. There's a resolution of the trade member saying that I'm okay to make an application. The name of the trade union shall not be resembling to an existing trade union. Okay, people come to this topic, recognition of negotiating union or negotiating council or industrial relation code. People, negotiating union. What is negotiating union?
Negotiation.
First is there is only one trade union.
Yes, sir. Yes, sir.
There is only one trade union. We call it as negotiating union. Or when we are having multiple unions, one person is having majority, 51, that is also called negotiating union. If there are multiple units, multiple trade unions, people who are having 20% support can be called as,
One representative.
one representative from each 20% will be called as negotiating council.
Constituted by the employer.
Employer.
Employer constituted by council. Committee number based on majority. Council employer now constitute.
Okay. Okay. So, for other people, less than 20 means put together there are some other units, one representation. There's only one trade union, that trade union is negotiating union. More than 51% is there, that majority person is called trade union. Multiple only, not having majority, anyone. Then 20% people will put together, will form as a council. Okay. People, general purposes shall be used for administrative expense, etc. Special funds, which is usually for a political, can be taken only with the approval of the trade union supporters, employees, and that amount cannot be used for any purpose other than only for the political party. Just because you are not contributed to the, if you are not contributed in general fund, trade union can suspend you. If you are not contributed to special fund, that doesn't mean that you have to suspend him. You cannot discriminate a person based on the fact that he is not contributed to special fund, specific funds, political interest of members. Remaining points are readable points, easy points. Okay, people, second point is in page number 138 regarding standing orders. People, what is standing order?
A standing order is rules of the
Is a bylaws of the establishment. We are done with trade union, now it's establishment bylaws. People, standing order applies to an establishment having 300 or more workers. What they have to do? They have to place their own standing order, comprising of every information you know, every chapters. How do I prepare, sir? If there is a model standing order given by the government, comply with that. If not, you are free to prepare your own thing. When you are making the standing order, make sure it is compliant with the model standing order. So you prepare a draft, give it to authorities. Authorities will call the representative from trade unions, employees. Then they will confirm and fix that. A very easy point, but give it a reading. What if they ask to be easy question? They ask comment on what is model standing order. General, pure general point, but you have to write. Now specific points for standing orders. Okay. Third exam question will fall under page number 145 regarding a person is suspended. Why? Why, Taylor sir? We are yet to see why suspension. An inquiry or investigation pending. Suspended temporarily, inquiry investigation pending. Then his family should not suffer. So we should pay subsistence allowance at the rate of 50% till 90 days. Remaining 90 days, 75%. More than this, you have to pay 75%. People, page number 145. Quick reading. Just have a quick reading of this thing, subsistence allowance. My inner instinct again says subsistence allowance. Give a quick read. So a worker is suspended, but the pending. What is pending? Inquiry or investigation is pending. Yes, you have to pay him subsistence allowance at the rate of 50% for the initial 90 days of suspension and remaining 75%. 90 days.
The excess of the first 90.
Okay. Now under this chapter they can ask you on redressal mechanism. People, when the question is regarding, so this is industrial relations now. You have to divide your chapter like this. Your two committees, grievance committee, works committee, then trade union. To not to have initiate a fight. If there is a fight, you have conciliation and tribunals. Before conciliation tribunal, you have one more option called as voluntary application to arbitration. So think that three angles. So arbitration is mixed, like other than these two. One, to avoid problems we have unions and committees. If problem happens, you can go with conciliation and like usual tribunal process. Before that, you can give a voluntary. So probably they can ask you, what do you mean by what is voluntary reference to? Arbitration under your occupational, trade industrial relations code. Okay. Key points are employer and employee together writing. They can go with this. Usually an arbiter should be a single digit number, even and odd number. And if it's even number, one person should be selected as umpire. People, it's a individual issue he can represent. Other than termination issue, he can bring it through trade union. Arbitration award should be given to appropriate government. Once the arbitration is done properly, you are happy, we will not entertain the strike or lockout. Non-applicability. Arbitration and Conciliation Act is not applicable for this point of arbitration. That's one part. Now people concentrate. We have something called as other machinery, called as conciliation officer. So conciliation officer is trying to mediate and promote the settlement of an industrial dispute. You have industrial tribunal where you will settle issue. When there is a problem, you will have an industrial tribunal. Two or more states are connected or national prominence is involved. You will have National Industries Tribunal. We have a case law which is connected to National Industries Tribunal. Which case law? National Industries Tribunal, one case law. Constitution chapter. Constitution, not here. Constitution chapter. Just take no Masdur versus Samadhi versus National Industries Tribunal. No. All India Bank Employees versus Industry. Or maybe trade union point. All India Bank Employees versus. People, next important question. How is the law regulating strike and lockout? How is the law regulating strike or lockout?
60 days prior information, but not less than 14 days.
Okay. Strike notice should be given within 60 days prior to the date of strike. Same thing, employer should give a lockout prior thing 60 days prior. No strike should happen 14 days prior to the, only after giving a 14 days notice. Then your strike should not happen any day before the date you have mentioned. You cannot do a strike during the conciliation or 60 days after that. Correct. Conciliation or 7 days after that. Tribunal pending or 60 days after that. Arbitration or 60 days after that. So people, how the law is regulating strike? No employee can go for a strike within 60 days of giving notice. They can go for strike only after giving 14 days notice. So day of strike, within 60 days you can file a notice. Strike should happen between 46th day and 60th day only. 14 days should be given. You cannot do a strike on a day other than the date which is mentioned. You cannot do a strike doing conciliation and 7 days prior to that, after that, post that. You cannot do a strike during an arbitration 60 days post that. Industrial tribunal and 60 days after that. Or when conciliation order is in place, you cannot do a strike or lockout. Easy points. People, layoff, retrenchment and closure. We are having 300 more employees. You have a layoff, retrenchment. You have to give a note. We have given a classification. You remember? Okay. People, can I claim layoff compensation? Yes, you can pay. You can claim layoff compensation provided you have worked for one continuous year. Continuous year we have already seen. Your name should be in muster rolls. Amount of compensation 50% of basic wage plus DNS allowance. Paid off for all days except weekly holidays. Layoff is maximum for a 45 days. Beyond that, you can't do a layoff unless there is an agreement. If the layoff is going beyond 45 days, better to retrench him. And retrenchment compensation can be adjusted with layoff compensation. Now, people, scenarios in which a worker is not entitled for compensation. If I give reasonable alternatives and he is refusing, I am giving an alternative employment within 8 km radius and he is not accepting, I will not give him compensation. Any day, he should be present there any day, morning 7 o'clock, he is not present. Or one department is making a slow process, causing a layoff in second department, I will not give him compensation. When you are retrenching a person, last in first out should be the rule. Within next 1 year, you are going for a rehiring. Try to take these people. 1 year, if you are having 1 year of experience, you will get a compensation on transfer of ownership, provided if the service should not be interrupted by that change of ownership, terms and conditions are not less favorable, or this should be part of your future compensation, gratuity computation, then it's okay. Otherwise, you have to give him compensation. Now, people, closure of establishment, also you can claim compensation. People, closing of a mine, you should give compensation. No compensation required when you are giving an alternate employment to 8 kilometers illa 20 kilometers. Not 8, 20. No break in service, and your future retrenchment is not affected. This has been added along with the normal retrenchment part. People, construction workers, work completed within 2 years, you don't have a retrenchment compensation, but the period of work is more than 2 years, compensation is eligible for a construction undertaking. Layoff of more than 300 workers in an establishment. You are having 300 more workers. Layoff is not allowed unless you take a prior permission of appropriate government. You will make an application. They will give the orders to the employees as well as employers. Conduct an inquiry. Then only you can retrench them. Normal retrenchment is fine, but the employment is having more than 300 people. Only after the approval you can get that retrenchment. So, people, make sure you are doing a proper comparison. Layoff, retrenchment, closure of establishment, and change of ownership for a normal establishment and establishment having more than 300 people. There's a different time gap. You have to be very clear. So, regarding layoff provision, retrenchment provision, closure of establishment related provision, and change of establishment related provision for a normal establishment and establishment having more than 300 people should be kept. 270, some points 210. Take layoff, retrenchment, closure of establishment, and change of ownership. More than 300 and less than 300. Separate category. Table. You have to make a table and study. You made a table, huh? Oh, good, good. We have made a table. Huh? Yeah, workers and appropriate government. Amount, other chapter. Your social security. That's for in a person. See, layoff compensation. See, if no compensation is given, you can go with that code. You'll have general provision with respect to compensation. If a code is specific on that, go with that. If not, you have other. See, our syllabus is not complete. You have compensation. It's not given here. You have there. Not in our syllabus. People, last two topics. People page number 165. Worker reskilling fund. You remember? Worker reskilling fund. People, 15 days wages should be given. Worker reskilling, when he is left out of a job and finding a new job for that extra class, attending a workshop, he might be paid that much payment as worker reskilling fund. Can be a question. Even page number 165. Worker reskilling fund can be a question. And should be paid within 45 days of that. Computation is 15 days, payment should be made in 45 days. Okay. People, last part. Then we are finishing. People, they can ask you unfair practices by employee and his trade union, employer and his trade union. So try to summarize. Unfair trade practices are all the bullet points, 5 bullet points each. Unfair trade practices done by an employer and his trade union or employee and his trade union. Okay. So remember those points. Unfair trade practice by the employer and a trade union. Important question. People, think about the points. You cannot let a trade union disappear. Force authorities not to start a trade union. Do a financial funding to a trade union. For an employee, you cannot break the equipments of the employer. So general condition with respect to unfair trade can be a question. So I think that's it. People done.
No code.
Watch that recording. No, if you get a clarity, watch that recording back. You have to make a table. That should be good. Because you are already having the most of the content in your head now. It's not good to read now. Either you watch the recording or take time and sit there. Make a table. It's not fair if you make a table now. It's konjam hectic. Table. So work on that thing. Take time when you are free, sit on that thing. Layoff, retrenchment, closure of establishment and change of ownership. For establishment, less than 300, more than 300. People, all the best. Okay. Done. So make sure it's done properly. All the best. Do well. Kambila will be fine. Setting up business also will be fine. So I'll see if I can do a marathon on Kambila also. I'll ask them. I'll do that. I'll ask them. Let's see. So online, offline marathon. Do well. Make sure it's done. Okay. Do it properly and try to finish your first group. Okay. Welcome to CS Profession. Null.
Yes.
For sure.
So we'll close the recording and then we'll talk. Konjan.